witness who recants victim intimidation by intimate partner abusers. The speakers for today is the Honorable Judge Diana Anhalt from the Philadelphia Court of Common Pleas, and we also have James Carpenter, who is the Chief of the Family Violence and Sexual Assault Unit with the Philadelphia District Attorney's Office. Today's objectives is describe forms of intimidation used by domestic violence offenders, and to identify strategies to prevent and combat intimidation in the courtroom. So now we're going to have Mr. Carpenter start the presentation.
Okay, thank you all for attending or not attending or attending by web. And I'm here with Judge Diana Anhalt, and we appreciate you giving us your time. We were interested in any questions you might have, and the more we can answer questions directly relevant to things you're interested in, that would be the most helpful. As your honors all know, domestic violence is a pattern of assaultive and coercive behaviors that can include sexual, physical, psychological attacks, and even economic coercion to gain power and control over intimate partners. Intimate partners, we're usually talking about people that have had sexual relations, whether it's boyfriend, girlfriend, husband, wife, gay partners, anything like that. One of the critical things that we see in these cases, as I'm sure all of you are aware, is the issue of intimidation. By its very definition, domestic violence is about controlling and intimidating the victim. It's not simply an anger issue on the part of the offender, but it's actual control. And you probably have seen these sort of things in the domestic violence cases you've handled, whether you've been in an individual courtroom handling a list of these cases or handling a jury trial. This is sort of a slide that illustrates some of the ways that a man may exercise control over his intimate partner. And it can go both ways. Women can do it, men can do it. Generally, we see men doing it to women, but you can see that they use things like intimidation. It can be physical force, but also looks, actions, things that trigger the memory of being intimidated. Emotional abuse, taking away her ability to think for herself and to assert control, isolating her, minimizing the behavior and blaming her for the behavior. I've had cases where women will come into court and have been, stabbed multiple times on prior occasions and will tell me, well, if I just didn't get him that angry, this is really sort of my responsibility, which of course outside of the situation is absurd, but if you're trying to control it without any power, that makes sense.
Hi, everyone. This is Diana Anhalt. Nice to talk to you all. I just wanted to add some of my experiences both as a prosecutor in the domestic violence unit at the DA's office, as well as a judge who handles these cases frequently. I think one of the things that I see a lot is people who say, I was only playing, or I would never really hurt him or her. And I think those are some of the more scary folks because they really are, in fact, hurting folks really badly, and they're not even understanding the nature of how horrible and controlling and violent their actions are.
And, our timing, I guess, couldn't be better than having the Ray Rice thing just come out. For instance, if you look on the left, the using the male privilege. In part of his apology, he said, look, I'm really sorry about what I did. It's my job to lead my family. It's my job to lead my wife. So again, you have that element of, I'm in control. And it's not just some sort of, feminist ideology, but it's something that's actually used concretely to control women to prevent them from leaving. And economic control. On the Ray Rice thing, we can see the fact that he married her immediately after this incident as a way, in effect, to probably buy her cooperation.
And Ray Rice's wife just issued her own statement, which I haven't read yet, but it should be an interesting read.
Yeah.
See what she has to say about that.
Yeah, and obviously that's a great example. It sort of elevates people's awareness of it. It's sort of like Jerry Sandusky did for child sexual abuse. And hopefully people realize that it's a complex thing, but also that the focus, and I'm a prosecutor, so I don't want to be unfair, but the focus needs to be sort of on offender accountability. It doesn't mean everybody goes to jail. It doesn't mean everybody is convicted, but we do need to intervene in these situations as a society. Perpetrators will create and exploit a victim's dependent, and emotional dependence can be things such as reducing her self-esteem. You're ugly, you're stupid, you're nothing without me. Isolating her from others, you'll often see these. And these are all things that you can look at in terms of risk factors as well for reoffense or for lethality or severity of, future possible abuse against that woman or another woman down the road. Tend to isolate victims. So in serious cases, often, as your honors all know, he'll be checking her cell phone when she comes home. He'll be dropping her off at work and picking her up from work. He won't let her leave the house without him being present. When she comes home, he's checking, the computer, where she's on the computer, where she is on her cell phone. Economic dependence, we see that as a huge issue. And from an economic perspective, it can make sense for a woman to stay in a relationship even at the risk of her own life when she has 2 or 3 kids with the child. He's providing the home or apartment. His job is the source of benefits, and he's providing the income. We see this a lot with police officer abuse. So where an officer may punch or beat his wife, it's very hard to get the wife to participate in the prosecution because she knows the officer is going to be fired. She's going to lose all her benefits. They're going to lose their income. So, those are really serious issues. Finally, offenders will use family dependence as well. So, in other words, don't take me away from our children. The children need me. He'll exert pressure through his family. And a victim's own family often will assert influence. In other words, the woman doesn't want to necessarily talk about the difficulty she's having, so she's going to hide it and be embarrassed. Research, it's interesting. There are 2 primary reasons that the domestic violence victims don't come to court. And this is from the practice implications of current domestic violence, which was a 2009 study of studies done by the Department of Justice. When I started doing domestic violence cases 15 years ago, there was all sorts of different theories and things that I was taught as a young prosecutor. And it was interesting to look at this study and see that a lot of the things I thought I knew were wrong. The 2 biggest reasons they will not testify or come to court is a fear of the abuser, which I think we all are aware of. And the second, and it's often bigger than the fear of the abuser, is the fear of speaking in court, particularly about personal issues. And the interesting thing is neither of those relates to whether the victim's going to be safe in the future. In other words, if she's absolutely terrified, she's less likely to come in, and she may be at more risk. If she's afraid of speaking in court, that has nothing to do with whether or not she's in danger or what the situation is. That's a totally separate issue. So as judges, it's sort of important to recognize that it's not that easy to come into court and talk about someone that you love who beat you and then you had sex with them because you were trying to calm them down.
I think we're probably going to end up talking more about this shortly, but we as judges have, I think, an obligation to try to address both of these reasons why any person who's afraid of coming to court, speaking in court, we have an obligation to try to make the courtroom accessible to everybody. And in doing that with regard to these kinds of cases, there are definitely things that we as judges can do to make this process less intimidating to the victim and try to sort of help with the fear issue. And I think we're going to get to this later in terms of what we can do in the courtroom, but it's, I think, our obligation to keep the courtrooms open to everybody and make sure that people do the best we can to issue protection orders, hold contempt hearings if it's violated, express in clear and no uncertain terms what we mean about having contact with a victim before court. And we can also, take it to the next level if the circumstances warrant it by excluding people from the courtroom if it gets to that level. So, and also assuring the victims through the attorneys that we're going to be very conscious of anything that happens in and around the courtroom in order to make it safe, to make the courtroom accessible to everyone. So I think we're going to get to that shortly, but that's just this is a good place to begin that conversation.
The victim fear is justified in domestic violence. That studies show 40% of abusers are rearrested for abuse within 1 year. The average rearrest is only 29 days after the first arrest. And in the weeks before trial preliminary hearing, you're going to see 50% try to talk the victim out of testifying, 30% stalk, and 9% threaten. And of course, it's hard to do these studies because there's a lot of underreporting, but these numbers really show you that upon an arrest, the incentive to pressure the victim goes up. So the danger to the victim goes up significantly at the time after the arrest when it's before your honors. And it's important to be aware of that. And as Judge Anhalt was saying, it's not only safety, but safety for defendants as well. If there's family violence, you want to elicit what the truth is so it can be addressed. Any kind of intimidation, and the bench book is really nice, really well done about that, whether it's coming from gang members or people in an intimate relationship, is a direct attempt to try to subvert the whole process that, you are the guiders of. And I know we talk about recanting witnesses, and really what this is more geared towards is just ways of trying to reduce and prevent victim witness intimidation in domestic violence courtrooms, whether you're doing a majors jury trial that's domestic violence or running a list. Here in Philadelphia, we have lists of DV cases that are run, and that's a good way to run it as well, but it can be helpful in that area. One key thing is having a separate waiting area for victims and witnesses. In our courthouse, we really don't have that. We have a victim witness room, but it's on the first floor. So we have our courtrooms up, 9, 10, 11 stories above that, and it's very hard to coordinate it. If you can find a separate room that's accessible to the courtroom or someplace where victims can wait, you'll reduce a lot of the outbursts that you'll hear in the hallway. A lot of these cases are explosive. Intimidation happens out in the hallway, in the anteroom, on the way in, before you even enter the courtroom.
Well, I think even before we get to the courthouse doors, in terms of having victims there at the same time, defendants are there, we have to talk about what exactly we could do as judges to try to eliminate the statistics that are on the prior slides about 9% threaten their victims and 29 days after the initial arrest. And in the weeks before trial and preliminary hearing, we have 50% tried to talk, 30% stalked, and 9% threatened the victim before trial. Now, what can we do as judges to try to at least address some of these things? And we have the power, obviously, to make sure defendants at the scheduling conferences, number one, are aware of what the conditions of bail are, and immediately tell them at the scheduling conferences or whenever you have the first opportunity to lay your eyeballs on a defendant, is to make sure that they understand that there will be no intimidation, there's going to be no contact, and there's going to be no contact even if the complainant tries to contact the defendant, that it's the defendant's responsibility not to talk to her, and that hopefully the DA's office will try to negotiate with the complainant to try to make sure she doesn't have contact with the defendant. But there's a lot of time that passes by, and I always try to make sure that defendants understand that my order is that he not contact her, and that if she contacts him, he's not allowed to talk to her and has to tell her that, so that I don't put any more burden on a complainant to try to smooth things over with the defendant. Because that's, in many respects, and I know I'm totally generalizing, but we are, in many cases, just trying to put the fire out and keep things as calm as possible so that we don't incite something later on down the road. And I see that a lot of times with victims. So that's why I always tell defendants when I have the opportunity that they're not allowed to contact. And if they do, a condition of their bail is that I will revoke bail if they violate a condition of that. We can issue other kinds of protective orders telling the defendant's family he can't contact the complainant. And the law is pretty clear about that. And that's at 18 Pennsylvania Consolidated Statutes 4954. And it permits a trial judge to prohibit acts of intimidation directed at a witness or victim that occurs outside the courtroom. So use that if, in fact, that's going to be helpful in your particular case, to limit that amount, the percentages that we talked about earlier. So doing those two things, then you have indirect contempt when someone who's not the defendant violates that protection order. If, say, the defendant doesn't have anything to do with it, but defendant's mom or defendant's dad, defendant's friends, brothers, whomever, go and try to contact the complainant, if your order is clear that it prevents everyone from doing that. Obviously, these things are very fact-specific, but it's things to keep in mind, ways that we can control what happens in and around the courtroom. And even before we get the complainants in the courtroom, I always make sure that people understand who are in the courtroom for trial what my expectations are concerning what their behavior should be like inside the courtroom. Because understanding that these are very intense, people's emotions are involved, and there's a lot at stake, and there are children's lives at stake, and folks are going to jail, and sometimes long-term relationships have exploded, and it's kind of a mess. And you sort of have to understand that. And when you tell people ahead of time what your expectations of them are if they're going to stay in the courtroom, and what your expectations of them are right outside the courtroom, because again, in my experience, we've had just as many incidents outside the courtroom as we've had inside the courtroom, with folks just getting very intense. It's very volatile. And so I always tell people that in and around the courtroom, there's no picture taking. Then we'll talk about cell phones too as we go along, because in our courthouse, that's a huge problem. We have so many policies in place to try to situate this problem, but quite honestly, none of them are actually working real well. But people take pictures and they take them outside the courtroom, and it's a real problem.
So as Diana was pointing out, that we would recommend you set the expectations at the beginning of court. Every judge has their own sort of practice, but it can be helpful to have your crier give these particular warnings before you even take the bench, and then for you to repeat whatever specific warnings you want as the first act you take on the bench, because it can really set the tone of the day.
Well, and I also think that in addition to this suggestion that Jim's going to bring, what we as judges need to also be paying attention for, and perhaps mention in addition to this suggested warning, is that any other kind of threatening sort of gesture, any kind of staring at people. I just had a domestic case the other day. It wasn't exactly the same, but it was a family violence case, a father and a daughter. And one of the other siblings who was watching the case, whenever the complainant would testify, and she was terrible with numbers, right? So she's giving the dates of birth of her children, and she was, saying, oh, he was born in 2012, he's 5. And then the people in the audience were so violently shaking their head and just kind of like, ugh, exasperated that she would be so stupid. And all the jurors were turning to look at these two people in the courtroom. And I didn't mention no head shaking, no gesture, and I should have prevent this. So instead, I had to stop the proceedings, take the jury out, admonish the people, and tell them if they did it again, they were going to be taken out. Now, that's a minor point, but I think it's one of those things where at first blush, it may seem kind of minor, but it also goes back to that whole power and control. And it's that whole thing about making a victim feel stupid. Oh, you can't even get this right, about the ages of your children. And it really is very impactful to have somebody sitting in the courtroom. It's her sibling, it's her sister, who's sitting on the side of the defendant and vehemently shaking her head, disagreeing with something that she's saying, even though it's about something innocuous. It is a kind of intimidation, subtle intimidation technique that people use in a courthouse, or even a defendant staring at a witness as they're testifying, or any other kind of person who's with the defendant, making just gestures or smirks or holding up hands to show a gun or anything like that. It's very important that we sort of pay attention to that and warn people ahead of time what will happen if, in fact, this is brought to the court's attention. And we're going to get into talking about contempt. But certainly, if these kind of warnings are given at the beginning of court, I would suspect that we would have the evidence that we would need, potentially, to have contempt hearings. That's how serious this stuff has to happen. When you're talking about statistics like the ones that Jim showed us with regard to why a victim's fear is justified.
Yeah, and if you think about it, the victim is in a cycle of being intimidated and being scared. And then to come to court and then be subject again to that kind of intimidation. I've had cases where women basically the crime is reported to police, she got beaten severely, police did stuff, and then she, went back. He continued to stalk her. She actually got back together with him because she felt that's the only way I'm going to stay alive, because he's been arrested for this crime and he's still doing this and nobody is stopping it. So, the idea is that in the courtroom, you rule the courtroom. You set the demeanor, you set the tone, and recognizing that a lot of victims are afraid to speak in public, putting them in front of an audience of strangers or family members only heightens that problem. Now, one of the first suggestions, and this is from North Carolina, had a domestic research group, was a lot of times victims will come to court and believe that they can drop the charges. And if they do believe that, and if the defendant believes that only increases the reasoning that the defendant should go after the victim and try to intimidate her. If we as the court, or we as the Commonwealth specifically, are saying, hey, it's up to the victim, then we're only encouraging defendants to intimidate the victim more so. The fact is the Commonwealth are the ones that bring the charges. So it can be very helpful if you're running a domestic violence list or any kind of domestic violence case to instruct them that criminal charges against the defendant are prosecuted by the Commonwealth. Victims and witnesses are not parties to the case and therefore do not have the authority to drop criminal charges. That can de-escalate the whole thing. The idea is that it's the Commonwealth's fault that this guy is in here. It's the Commonwealth's fault that the victim has to come in and testify. And that can get us closer to what the actual truth is.
Also to say, to make sure that you give victims a chance to be heard at some point during the process, because they can oftentimes say, I'm doing what I'm supposed to do because the infamous they subpoenaed me, and making sure that the prosecutor or that the judge has told the victim that they will get a chance. I sort of would do this a lot with victims who were, a little hesitant about testifying, and be like, look, you could tell the judge you don't want to testify. You could tell the judge that, you want to drop the charges, but just tell them the truth too. So we as judges have to be probably a little bit more patient with these types of cases than we are with some other cases, just because there is so much at stake. So like making sure that victims have a chance to tell the judge, and that sometimes will help de-escalate some of the tension as well.
You're not removing the victim from the equation. I mean, the
Ever.
research shows that what the victim wants to see happen in the case is not always the best outcome in terms of her own safety. However, the victim is a good predictor of her own safety. So, she may want to drop charges, but it may not be the best outcome in terms of her own safety.
How does the DA's office, Jim, then draw that balance between not forcing domestic violence victims to testify versus having obviously an interest in prosecuting violent criminals?
I mean, we would have contact with the victim shortly after the arrest. So we have a process for doing that where we can get input. But the main thing you want to gather is the background of the case and what their history is. So like the average person who applies for a PFA, the average woman, she's gone through 12 to 13 acts of being beaten before she even goes to get a PFA. That's what the research shows. So the problem you handle as a judge is you don't know exactly what you have in front of you. You could be handling a violation of a PFA where he came to the house and yelled a threat, and it doesn't look that serious. But she's not telling you the fact that the reason she's so scared is he stabbed her or burned her before, and she never went to the hospital. So you need to know the history of the relationship as a prosecutor and as a judge. I mean, we're asking you to make sentencing decisions based on what you think is going to happen and what's best for both parties. And quite frankly, what the research shows, and this is off the topic a little bit, is, sometimes incarceration is necessary for a lengthy period, but also there are ways you can put someone on probation with a whole lot of conditions. All right, you got to go to batterer's intervention program. You can't be drinking. I'm going to have drug tests on you. And if you do those things and you have tight supervision or even status listings where he's got to come back and tell you how he's doing, once he makes a mistake, in other words, he comes back with a hot urine for pot, or he misses 2 batterer treatment, and the PO lets you know, you can intervene at that point. And it doesn't mean you put him in jail for 6 years or a year, but it does mean you bring him in and maybe you verbally reprimand him, maybe you put him in jail for that day, but there needs to be immediate consequences for him dropping off the wagon. The idea is that it's like a canary in the coal mine. So you want to intervene before he takes the final action of killing her or getting more assaultive and stuff. And that's good for him as well. A lot of these men, they're good men, they're good people. They have serious problems and they need to be addressed. And if they're not addressed, they're going to end up in prison for the rest of their life. That's just a side point. But returning to the warnings, and you would do these however you want, but these are some of the suggested ones in the bench book. Any criminal conduct will be referred to for arrest. The fact that you can hold people in contempt. We move to the next one. If you misbehave, you can be excluded from the courtroom. And probably the most important one of all time is any cell phones or other electronic devices that are not powered off and out of sight will be confiscated and searched and may result in criminal contempt or your expulsion from the courtroom. I guess we could sort of talk a little bit about cell phones at this point.
Does anybody out there have any interesting ways they handle the courtroom cell phones? Because here in Philadelphia, obviously, we have a lot of people coming in and out of our courthouse every day. I don't even know the numbers, but I suspect it's in 5,000 or 6,000 people every day. And everybody has at least one cell phone. Folks are coming into the courtroom, to the courthouse, and they have their phones with them, and they're told to turn them off. So 9 times out of 10, what they do is they turn them on vibrate, and then they continue to text and play games or bring their children with them, so they're watching cartoons with their children. So we obviously have to do something about that. And usually, we tell people you got to turn it off. And I, during trial, will always say to people before I bring a jury out, I give you 30 seconds now to power your phone off, not to put it on vibrate, not to turn off the volume, but to turn it off. Because if you look at your phone from this moment on, I'm going to assume you're doing something not so good with it. And then people will be like, oh, okay, I didn't get it. So then they'll turn their phone completely off. I have had in my courtroom a person take a picture of a witness right outside my courtroom, on the bench outside the courtroom. And one of the witnesses knew that it happened, saw it happen, heard it happen, and heard the person say, yeah, I got his picture. They brought it into the courtroom for me, and I talked to the woman about what was on the phone, and she assured me that there would be no pictures of the witness on the phone. And I said, look, here's how we're going to do it. We're either going to get a search warrant for your phone, or you can allow the Commonwealth to take a look at your phone. And she said, by all means, go take a look at my phone. And lo and behold, I don't know what she was expecting, but there really was a picture on the phone of the witness. So the Commonwealth brought charges against her and treated it very, very, very seriously. I've also had people in my courtroom take pictures of me on the bench, which, fortunately the flash went off. And so I saw the picture being taken, but if the person who did it had used his brain and turned the flash off, I probably wouldn't have known. Fortunately, in this situation, my staff saw it, I saw it, we were able to do something about it right away. This is such a huge problem because people tape what's going on. I'm not exactly sure how we're going to handle it.
Taking a photograph of someone can basically be intimidation. And what we're seeing with gang violence and domestic violence is people then post the photograph to Facebook or Instagram or some social media site and say, this snitch is talking, go get him. And so we see that happening. And you might ask, well, what gives you the permission to ban cell phones from your courtroom? Well, it's Pennsylvania Rule of Criminal Procedure 112, Section A. And what that does is it prohibits the taking of photographs or videos of any judicial proceedings or in the hearing room or courtroom or its environs during judicial proceedings. So having a phone that's on gives you the potential to take photographs. And you don't need to actually, I think, prove that they've taken photographs. There's no way that you can control whether they're taking photographs, as Judge Anhalt indicated. It also says it prohibits the transmission of communications by phone or other technology from the courtroom or its environs during the progress of or in connection with any judicial proceedings, whether or not the court is actually in session. Theoretically, that can include texting what somebody is saying. It can include taping it and posting it to a website. It can include recording it. That is the grounds that you would cite for all phones have to be off. And that includes the environs is not just the courtroom, but it's also the anteroom and the hallway outside the courtroom. That's the justification for it. If you give that warning that, look, you're either going to be held in contempt and it may be seized, if you see a phone in violation of what you've directed them, you should seize it. Store it together with photocopy of the owner's identification, and then it can be searched.
I actually don't think there's any need to take a phone you're not willing to also search in many regards. You make an announcement that your phone has to be off and out of sight and not taken out, or otherwise it will be searched. Because quite honestly, if you give that warning and someone violates that warning, they're not doing it to watch cartoons on the phone. They're doing it for some reason that they shouldn't be doing it. If we're taking phones and you're like, oh, you can come back at the end of the day, and you're handing a phone that has a picture of the victim on it so that it can be posted on Facebook or Instagram or any one of those things, that's a real problem. Just reminds me when Jim mentioned about Facebook, I always try to include in warnings given that you can't have contact with victims. You can't talk about cases on Facebook, Instagram, Twitter, or any of that, because people are like, I didn't contact her. I just posted naked pictures of her on Facebook. And that's a violation of what we should be concerned about. Yes.
Your Honor, you had asked if anybody had any ideas about taking the phones away during court. And one judge, any phones turned on in the courtroom are confiscated by the sheriff and returned at the end of the proceeding with no exceptions. And also, counsel wishing to have phones in the courtroom must file a request for same, which is approved by the court.
That's a great idea.
That's good.
I mean, because you do have that difficulty with attorneys using their phones where you're not quite as concerned because they're officers of the court of them abusing the privilege. Have you seen that be an issue where people are like, well, the attorneys have it, why can't I? Or
yes, for sure. When we give our admonition in the beginning of the day, I try to tell people who's allowed to have a cell phone. Anybody who's not there working. If you're not there as a police officer or you're not there as an attorney, you're not allowed to use a phone. And I say that to people because I don't want them to think that I'm not being fair. Like, oh, this side can use it and this side can't. We have a lot of plainclothes officers in the courtroom. They're using their phones because that's the way the DAs get in touch with their, our police officers have 16 rooms that they need to be in sometimes. And DAs will text them or call them, and our DAs the same thing. Like, they're everywhere. So that's a way that we stay in contact with each other. Obviously, or the DA's office stays in contact with their witnesses or each other. So it is important to let people know that there are some people in the courtroom who will have phones, but they're not witnesses and they're not here with witnesses or people here with defendants. I do take phones. People will come back. Lawyers will say, oh, Judge, this case is finished for the day. Can the mother of my client please have her phone back? And I say no. I say, you got to come back at 4:30. That is when court's over. And if I have 30 cases on my list, some of them are extremely serious. and I can't be worried about who gets their phone back at 12 and who gets their phone back at 4:30. And so I tell everybody 4:30. A couple weeks ago, had a lady come back at about 4 o'clock to get her phone, and she parked illegally outside the courthouse. So she went up to get her phone from my courtroom, and my staff was waiting for her. So she came back downstairs, and when she got there, the police tow squad was towing her car. So she was not.
But she had her phone. So
she had her phone, right? Yeah.
Back.
So she was not happy with me.
This is another thing that we had talked about. Just be aware that often, you may have an impulse to ask the victim in open court, well, what do you want to see happen? I see you're here with him, that sort of thing. I would strongly recommend not doing that because, again, you're heightening the level of intimidation and you're putting more control into the defendant's hands. Separating the parties in court. All of you have a way of separating victims and defendants and that sort of thing. There are a variety of different ways of doing that. You can announce it. It can be victims behind the prosecutor, defendants behind the defense attorneys, that sort of thing. You can also have an area that's just for victims. A buffer zone can be helpful. So one of the ideas is Diana was talking about is, when people are glaring or they're making hand gestures, obviously you want to stop that immediately. But if you can create some physical distance between witnesses and spectators, that can help. So you can limit the front two rows to being attorneys, press, students, people that don't have necessarily a dog in the fight, and that can be helpful. The key thing is that, as Diana has indicated,
he calls me Diana, by the way, because he used to be my boss at the DA's office. I'm not his boss, but he'll never get used to calling me judge.
I'll call her judge.
No, you don't have to. It's just these people don't know us, so we don't, right.
As the judge said, it's important to prompt onto that misconduct. If you let any of it go on, other people are going to see that and pick it up. If you single someone out early on, you don't have to lock them up, but you single them out, that really sets the tone. Staggered release, I'm sure you're all familiar with that. It's not a great idea to have everybody leave at the same time when there are two warring families, unless you're going to have 5 sheriffs out in the hallway just waiting for it, because you will hear it in your courtroom. So you can ask the spectators to leave the courtroom before any other people, or let the defendant and his family leave first. However you want to do it. Continuances are a huge issue in these types of cases. And certainly there are reasons that a Commonwealth or the defense may legitimately need a continuance. But there is no question that continuances raise the danger to victims. Defendants may use multiple court dates as a way to access the victim or delay the case in hopes of intimidating or wearing down the victim. So in other words, if she's got to come in 3 separate times, or every time she comes in, it gets continued because the defense attorney is not available, or the defendant needs further investigation, you're not only frustrating the victim's ability to get any kind of justice, but you're also extending the danger period by extending the period of time that this case is in litigation, which is the most dangerous time for victims. Every time that there's a listing of the case, the risk of intimidation and danger to the victim goes up in the days preceding that listing. So if you give it 3 continuances, you're talking about 3 different dates where you had chances of additional danger. There's a variety of ways, and various studies have shown that continuances are a real serious concern in the area of domestic violence. Not just because people get back together, and that's fine if they want to get back together, but it is a cycle. You must submit a request for continuance 48 hours ahead of time in writing. Fax it to my office. If you set those sort of requirements, it will reduce the number of continuances that you actually end up granting. Those can also include requiring that all motions be made in writing, which prevents extraneous motions. You can limit how many continuances each side is going to get, but just have some rules on that. Judicial demeanor. This, again, is based on this meta-study of about 400 different studies, indicating that the judge's demeanor is crucial. And they studied judges who just really did not take domestic violence cases seriously, did not believe there should be in court, thought it should be just dealt with by the family, and they found statistically that it reduced the number of arrests in the community and prosecutions in the court. It sent a message, and it really reduced the enforcement of the law. And every judge is different. I'm sure you're all good-natured. These are attributes that facilitated victim cooperation. Being good-natured, not being overly formal, not being overly rigid, not overly authoritative, being supportive and informative towards the victims, as well as anyone else in the courtroom. And that includes the alleged abuser. And once somebody is found guilty, being firm with abusers, not allowing any kind of intimidation to occur in the courtroom. Judge Anhalt talked about this. Obviously, as a condition of bail, there should be a stay-away order. And one key thing is to include in that your magistrate or your district justice that's making that determination is including that no Facebook contact, no text contact, no phone contact. As the judge said, you need to take these violations seriously. It can be difficult, but if you're going to issue that order, you need to respond to it. So as Her Honor indicated, you can hold without bail, you can increase bail, you can put a person on house arrest, you can even have a hearing where the defendant has counsel and he can be held in contempt for violating it. One thing I would note is that we've all seen cases where the victim is reaching out to the defendant's calling her back, and it's back and forth. And judges often will say, well, look, I'm putting a stay-away order on the victim as well. Well, technically, you don't have the authority to do that. You should feel free to call the prosecutor up and say, you got to tell her to cut this out. And it's reasonable, I would expect, as a prosecutor to be told that, and for me to go out and, frankly, reprimand the victim and say, you got to cut this out.
I just had this come up in a case last week it wasn't a domestic case, but it was a case where two people knew each other. One allegedly shot the other one. The jury acquitted, and the defense attorney asked me, and the victim was in the room at the time, and the defendant was there, and the defense attorney said, Judge, could you issue a mutual stay-away order? And I looked at him and I said, under what authority? Do you want me to just say, you stay away from him, he'll stay away from you, and give people a false sense of security? And I think that we have an obligation to not just do the knee-jerk thing, which is to say, you stay away from him, because you can't enforce that, obviously. So that's why I specifically tell a defendant, say, who's in custody, you can refuse a phone call. You can refuse a visit. And that's your obligation to do that, because your job is to stay away from her. I don't care what she's trying to do. Your lawyer will find out if she's coming up to the prison to try to see you. And he'll use that if he thinks it's appropriate. But your job is to not take phone calls or not call her. Obviously, he can't take calls in prison, but it's to not take visits if she shows up. The problem becomes many times is that she has control of the child, right? So the defendants want to see their kids and stuff. That presents a different kind of problem. I always feel like we need to just have a status quo. We just need to chill everything out until we can have an adjudication of the case. Because much as we all like to be helpers, it's kind of hard in our role, I think, as judges to do all that. Once you have an adjudication of the case, I sort of have to rely on social services to help the woman or help the victim navigate what's going to happen next when he gets out of prison and things like that. To encourage people to get PFAs, sure, but there's a lot of other factors that are going on behind the scenes. That's how I handle the stay-away order, is to really tell defendants what my expectations of them are, because I can't control necessarily. I can in a protective order for outside the courtroom, but I can certainly have control with respect to the defendant. And I've also taken phone calls, visits away from people in prison. And that is a huge thing that we as judges can do to prevent intimidation when it's really bad. I had a guy who's planning to kill the witness against him. Well, he's not making any plans now because the only person he's talking to is his lawyer. The key to this is to have hearings where you prove in a contempt hearing, obviously beyond a reasonable doubt, that violations have happened, or prove at a bail, a motion to increase bail. Certainly the level of proof is a little less, and you can then use these things, but you got to have hearings. Let people put this stuff on the record so that you can make informed decisions when there are potential violations.
These are some of the pretrial conditions that you should be aware of that prohibit intimidation. Commonwealth versus Lynch is something that we wanted to talk about. It's a recent case that just came out from the Superior Court, and what's unique about it is this was basically a case, a man had beaten his girlfriend really severely with a baseball bat, and then subsequently called her from jail while awaiting trial on that, and was asking for her to not go to court, but not threatening her. Days later, he's calling and sending her letters from prison, begging her not to come to court so he could return home. Let me help with the kids. I'll give more stability. I'll use our income tax refund to start fresh with you and the kids. In that case, he was charged separately with intimidation for those letters and those phone calls, and he was convicted of intimidation, despite the fact that he didn't make explicit threats of violence. And the Superior Court upheld it and said that the defendant's promises of providing improved household stability and financial support for her and the children, including sharing their tax refund, was an offer of pecuniary benefits to the victim to not appear in court, and thus was a violation. Basically, there are really two things that come out of this. One is that even apologies and pleas for compassion and forgiveness, where you're asked the victim to not come to court, can be interpreted, depending on the circumstances, as being a veiled threat. It's significant that you need to know the dynamic between the two individuals and the circumstances of their history to determine whether when he's saying, I'm not going to do this again, we can get back together, whether that's actually a veiled threat. And then the second point, there was an actual pecuniary benefit. So the Superior Court ruled that the promises to be better and the apologies and the request to reunite the family could be seen as veiled threats based on the danger, based on their history of violence. But they also said that promising to share the tax refund and promising to provide stability in the home life in terms of finances was an attempt to bribe, effectively. It was an attempt to offer pecuniary benefit if she decided not to come to court. So that's something that's extremely significant to know that type of manipulation, not in every case, but can be seen as intimidation.
And at the very least, it can be seen as consciousness of guilt. A jury charge is appropriate when people do this sort of extracurricular contact with a complainant before court. If it doesn't rise to the level of guilt beyond a reasonable doubt with respect to proving intimidation, consciousness of guilt and the behavior of the defendant showing that he knows if she shows up, you're going to believe her. That's how I would argue that as a prosecutor, and I would expect that that's how I'd give the consciousness of guilt jury charge with respect to that kind of behavior.
Obviously, Your Honors are all aware that if a victim is there or a witness and they are getting on the stand and telling a completely different story, that the prosecutor can introduce under Brady Lively their statement, and if they adopt it, that can be used as substantive evidence. So that deals more with the recanting witness who comes to court and has totally changed their story, and I don't want to get too far into it.
For that sort of thing, can't you have the detective who took her statement who says she adopted it at the time she gave it? She doesn't have to adopt it in court. That's the important piece to that, I think, is that she doesn't have to. She can adopt it at the time she gives it.
So if she gets on the stand and says, "Oh, I didn't give the statement, but and this is what really happened," if the prosecutor presents the detective to say that's her, she signed it, this is her statement, that can be used to hold the case for trial. And again, a lot of victims go south, and the dynamics are understandable. However, we run a real risk of there being a homicide or further injury if the state doesn't step in and try to stop this cycle. Now, we want to talk about 4 ways to proceed when a victim is not present. And this is detailed in the intimidation bench book. These are some of the mechanisms if you're dealing with intimidation of a victim whereby a case can still proceed. The first is former testimony where the victim is unavailable. The second is defendant's forfeiture by wrongdoing. 3 is excited utterance. And 4 is admission by the defendant. This is under Rule 804B1. So there has to be established that the witness is unavailable. Then it has to be determined that the testimony that's being offered is former testimony, namely that the defense had a full opportunity to cross-examine the witness at the time of that cross-examination, that they weren't missing extremely materials that would be a basis for cross-examination, and that their cross-examination was not severely limited. The first step in this process is your honors would have to make a factual determination in your determination whether the victim is unavailable. And they can be unavailable. The Commonwealth can show attempts to try to find the person. If those are reasonable and they're unable to locate them, that itself can be a finding of unavailability. Likewise, and good faith effort is left to the discretion of the court.
It's also important to realize that unavailable also can mean a witness who refuses to answer questions despite being held in contempt, despite having their recollection refreshed. A person who just gets on the stand and says, I got nothing, I'm not testifying, and speaks no words. That can be unavailable. That's Commonwealth versus Nelson, a 1995 Superior Court case. And there's others that say the same thing.
And in addition, if a witness is unavailable because of a threat, that makes them unavailable, and you can present the former testimony. Now, what is qualifying former testimony? Your honors are all familiar with this, but I'll touch on it briefly. Is testimony given as a witness at another hearing, taken in compliance with the law, and the party against whom the testimony is now offered had an adequate opportunity and similar motive, basically the same party, to develop the testimony by direct, cross, or redirect examination. And this is parallel to the federal rules, which were the basis for the Pennsylvania rules.
Well, just to add in here, too, as well, in the bench book, it talks a little bit in there about whether or not we would allow adult witnesses to testify in the same manner that sometimes we do children in terms of closed-circuit television or remotely. And it's very interesting to me because although the question is, don't you need a rule of criminal procedure to allow you to do that? And how does the court obviously ensure a defendant's right to confront witnesses? And interestingly enough, other jurisdictions have done it despite the absence of a rule of criminal procedure specifically allowing them to do it. So in the case where a witness is, say, a domestic violence witness has left the jurisdiction, refuses to tell anybody where she is. And the Commonwealth can't subpoena her because they don't know where she is, or they know where she is. She's outside the ability for them to subpoena her. There is some arguments to be made. There's a New York case that talks specifically about if the state or the Commonwealth here can show a compelling interest in justifying the absence of live testimony.
There's a few examples here that you can look at yourself. This is one where a deceased eyewitness's preliminary hearing testimony was introduced because there was a full opportunity to cross-examine. Even when some of the materials were not provided to the defense, they have to be material. So this was a case the defense did not have her medical records or the DNA test result at the time of the hearing, but the Superior Court said it was still proper to admit the complainant's preserved hearing testimony at trial. The second area is forfeiture by wrongdoing, which is under Rule 804b6. This is a situation where the defendant, by his own wrongful conduct, has made the declarant or the witness or the victim unavailable. This can range from threatening the victim to killing the victim. Basically, the court would conduct an evidentiary hearing outside the jury's presence, obviously, to determine if the statement is admissible. Your Honors, it would apply the standard whether the Commonwealth has proven by a preponderance of the evidence that, one, the defendant was involved in or responsible for procuring the unavailability of the declarant, and two, the defendant acted with the intent of procuring the declarant's unavailability as an actual or potential witness. So, as your Honors all know, you can't win by trying to manipulate the system. So if you intimidate a witness, if you kill a witness, if you prevent a witness from testifying, and that is your goal, you don't get the benefit from that. A lot of these cases are federal cases because the Pennsylvania rule is predicated on the federal one and they're identical. This is a Hawaiian case where a DEA agent was allowed to testify, where the witness was unavailable because he refused to testify because he had been threatened. There's an interesting case in the Superior Court, which is Kunkel, where a murder victim's statements to his child custody attorney were admitted, where the defendant had murdered the victim to make him unavailable for the custody hearing. So he was the father, mother killed him, and she therefore forfeited her right to confront him.
So Jim, how does this play out when it's obviously not a murder, but how have you seen this?
It would primarily be in situations where a witness is not coming into court and we can present, for instance, prison tape of conversations they've had or other people that they have contacted who have, on their behalf, asked them not to come to court. There has to be a separate finding, not only that the person is not absent just because they're sick, which would be a different type of unavailability, but they're absent because of this type of conduct that was intimidating them. And then the second step is you have to show that it's connected to the defendant. It can't just be some other person intervening. You can show kites or letters in jail where the defendant is asking people to go intimidate someone or kill someone. You can also, if a victim comes into court and they refuse to testify, they may be willing to testify outside of everyone's hearing, in a hearing about what the actual threats were and the intimidation, and that might be sufficient as well. It is unusual, but what we're seeing is a larger technological as well as aggressive attack on the ability of the courts to have witnesses come in and tell what happened. Just get the truth. That's all that you're looking for. These are people that are really trying to prevent that from happening, and it's an attack on the entire system. These are just some of the tools. It's not an easy thing to show, and there's a few more examples there. We would have to show that the defendant was involved in it. This is an interesting case where they had to show that not only did the defendant kill the witness, but that he killed the witness because he didn't also want him to testify in the underlying case. So he might have had other reasons for killing him, like I hate him, or he stole money from me, so I murdered him. But by the way, I also had this ag assault case where he was the victim, and that's a bonus. So that was sufficient to bring that in. Cited utterance, your Honors are all aware of, the spontaneous declaration by person subject to overpowering emotion. In more serious cases where the Commonwealth says we need to proceed with this case because there's a real danger to this person. Either she's not able to protect herself, she's too scared to come in, whatever the reason. And it shouldn't be done flippantly, but the fact is there are many cases that have to be pursued even where the victim doesn't want it pursued. And often we can present those cases by presenting testimony from the responding police officer, from the responding medic, as to what the victim said at the time that she'd just been hit. What has to be shown is that it's made in reference to some phase of that occurrence. It's not something saying, I hate my grandma when I was a little girl. It has to be related to what just happened. And it has to be so close to the occurrence in time and place to exclude the likelihood that they would have had time to think about it and make something up. You might think that that's only like the 10 minutes that happened while the victim is bleeding. And that's not the case. Statements of victims victims and witnesses to shootings to emergency room personnel and to police have been admissible. Statements to emergency room nurse several hours after the assault held to be excited utterance. So you're going to look at what was the demeanor of the declarant as it's described by the officer or the medical technician. Were they upset? Were they tearing up? Were they shaking? What was their complexion like? What had they just perceived? How upsetting was that actual act? To determine whether they're saying this as a reflex rather than as some sort of planned deception. 911 call tapes, again, those can also be introduced, although the Commonwealth must prove that the caller actually saw the shooting that they're describing, and even questioning by the dispatcher will not render it non-excited utterance. The next area, by admission by the defendant. Often you will see cases where a victim, the 48 officers as we call them, respond to the scene, the victim is bleeding from the head. She says, hey, nothing happened, and the defendant says, I punched that bitch in the face, I'm going to beat her ass again. Now the victim doesn't come to court. The case can be put up with the officers stating what the defendant said at that time and their observations of the injury, which would be the corpus to establish that the confession is to a confession to a crime that actually occurred. So that's another way that cases can be put up without a victim being present. Something that Judge Anhalt talked about, which is this is not a way of proving the case, but that acts of intimidation come in to show consciousness of guilt at trial. And there's a case, Commonwealth versus Flamer, where the trial court was actually reversed because it refused to allow in acts of intimidation that occurred to the victim at the hands of the defendant up to the time of trial. And an interlocutory appeal was taken, and the court reversed that and said, no, that all has to come in. The defendant has to be in some way responsible for the act. So here's just a couple examples of testimony. The defendant had offered a bribe to the witness to not come to court. Well, that's consciousness of guilt. So again, under the Lynch case, the promise of I'll share the tax return with you, we'll get ourselves financially together, that could come in as consciousness of guilt. Threats towards the witnesses obviously would come in to show as consciousness of guilt. I don't want you to testify. Well, why not? Because what you're telling is the truth. Evidence that they threatened to kill the witness if she testified, that was also admissible.
There was one thing I wanted to talk about when we talked about what we can do in the courtroom, and something that comes up oftentimes in our courtroom is excluding people from the courtroom, the exclusion of spectators. And obviously we're balancing public trials and the Sixth Amendment, as well as the First Amendment, freedom of the press, obviously that relates to other people as well, versus our responsibility to maintain a fair and safe and secure courtroom. So in balancing those things, this is where the contempt process comes in, where people who make faces and the gesticulations and the staring and any other visible reactions to testimony, those folks can easily be removed from the courtroom, number one. And number two, they could potentially have contempt hearing. But if you're just going to exclude people from the courtroom, you must obviously make a full record and make explicit findings describing what the offending conduct is. Hold a hearing, obviously outside the presence of the jury, and make a factual record. So you need to exclude just the offending person. And also consider what other steps can be taken to ensure a safe courtroom. For example, do you need to get more sheriffs in the courtroom? Do you need to have police come and sit in the courtroom? It's not good enough to just take the word of the DA. I always say to the DAs who want to tell me what happened outside the courtroom, have a hearing, put a witness up, let me swear somebody in and get them under oath so that you're covered for appeals. I know, at least myself, I would rather not write appeals, but when I do write appeals, I like to make sure I did it the right way. So knowing that you've had some kind of hearing that addresses not just a generalized fear, but or not just your preference not to have the defendant's mom and dad and entire family sitting in the courtroom, but you have to talk specifically about having that specific threat or a specific reason why you want to try to exclude somebody from the courtroom. But it certainly is an option that we have in our arsenal to keep our courtrooms so that folks have access to justice.
I would just note one thing. In the meta study, if you look it up in the sites in the PowerPoint, as judges, it's difficult to predict who's going to reoffend, who might not reoffend, who's a lethality risk, who's not. And a lot of the research, it's interesting, shows that any prior criminal record, whether it's DV or not DV, is a strong indicator of risk. So a lot of times judges, prosecutors, and defense attorneys will think, well, he's got a string of robberies, but they're not domestic violence related, so he's not a real risk for domestic violence. And the research shows the opposite. So you want to look at his entire criminal record. Because again, you're trying to predict how best to protect community and what is needed. First-time DV misdemeanor offenders with no prior record, they're a low risk to reoffend. A couple other interesting things: if there were previous threats to assault with a firearm, it's 20 times more likely a homicide. Threats to kill, it's 15 times more likely to result in a homicide. Prior attempts to strangle, it's 10 times more likely a homicide. Escalating violence over time, 5 times more likely. Partner control over 5 times more likely to be a homicide. Stalking is a real red flag. And a firearm in the house makes it 6 times more likely that you're going to see a homicide. Drug and alcohol addiction increases the risk 8 to 11 times. So if the guy drank that day, the risk of violence goes up 8 to 11 times what it would be if he had not taken drugs or alcohol. So that's why it's so complicated, but those are just some indicators of what are and are not risk factors.
And so that's why at sentencing, you can make no drugs, no alcohol, no firearms in the home, and any of those other risk factors that Jim just mentioned, you could try to regulate that with whatever sentence that you give. All right. Thank you.
Thank you.
I would like to thank James, Your Honor, Anwalt, for being the presenters, and we greatly appreciate it.
Thank you.
Thank you.